Item number
11. Can you pass over the date?
All right. As prayed for by Ms. N. Mahajan, learned counsel appearing for the appellant, list this matter
Only for the day, madam. Stay only there with
in such and such date.
can be before before.
Before,
Yes, sir.
before not possible.
Can you pass over the day, madam. Only that much.
All right. As prayed, the matter stands passed over for the day.
Very good. Obliged. Maybe. Why not I beg to matter number 28 of supplementary day, madam. Uh, Item 28 of supplementary day.
Item number
28
wait.
Fine.
Yes,
supplementary day.
or supplementary.
Fine.
Yes,
In this case, my lord, I am the informed and I have filed an IA, my lord, for implementation for that.
have you informed the other side?
Yes, yes. My lord, that I has been numbered, but it has not been listed, my lord. Yes, let us come upon another thing. Along with that, I,
Mr.
yes, number.
Mr. A.
Yes, number.
J. Islam, learned counsel for the respondent,
My lord.
submits that in connection with the anticipatory bail application, he has filed an interlocutory application being IA
IA number, my lord, 256
IA number 256
of 25.
of 2025. However, the same is not listed today along with the bail application. Stop. Let the anticipatory bail application be listed on such and such date along with IA so and so.
Interim is there.
Interim, if any, shall continue till the next date of listing.
May I please your lordship? Lordship, I pray for listing of a fresh urgent matter, lordship.
I think
Lordship.
there are senior benches available, so you make this prayer before the appropriate bench. Yes.
May I please, your lordship? I beg to mention item number 26.
Yes.
In this case, lordship, I want to withdraw this.
Withdraw.
Yes,
You are Mr.
M.A. Mondal.
In item number 26. Heard Mr. M.A. Mondal, learned counsel for the petitioner, also heard Mr. P. Bhattakur, learned APP for the state respondent. Mr. So-and-so Mondal, learned counsel for the petitioner, submits that he has received instruction from the petitioner not to press the anticipatory bail application and accordingly seeks withdrawal of the same. Prayer is allowed. So-and-so stands dismissed on being withdrawn.
Obliged, sir.
Lordship, in item number 23, Lordship.
Was there any interim in the anticipatory bail application in 26?
Lordship, in item number 23, Lordship, I filed an additional affidavit. Lordship may be called for.
Let's call the list. Yes, Mr. Das.
My lord, this is a revision petition, my lord. Challenging the judgment passed by the learned session judge. Upholding the conviction under section 420.
Just one second, class. Yes.
The notice will go, my lord, it is revision petition, my lord.
What is the order under challenge?
When order is at page number 51. The session judge has upheld the conviction of the applicants under section 420 IPC, my lord, and sentence is for a period of 6 months.
Heard Mr. S. Das, learned counsel for the petitioner, also heard Mr. P. Bhattakur, learned APP for the state respondent. Stuff. This revision petition is directed against the judgment and order dated 19/3/2025, passed by the learned session judge Karbi Anglong Difu in criminal appeal number 3 of 2022, and the judgment and order dated 23/2/2022, passed by the learned subdivisional judicial magistrate M. Bokajag in GR case number 450 of 2015. whereby the judgment of the trial court acquitting the petitioner was upheld. Correct?
Oh, my lord, acquitting the petitioners under section 406.
Okay. Whereby the conviction and sentence of the petitioners under 450, under section 4, under
420.
section 420
Okay.
was upheld. Now, issue notice returnable 2 weeks. Lord Thakur accepts for R1, no formal, no extra copies within so and so. For 2 registered post AD, steps 3 days, list after 3 days. And a date to be fixed by the registry.
IA, madam, IA said, for allowing to remain on previous bail.
Yes, IA, any objection?
No.
In the IA use name, Mr. Hurd, Mr. S. Das, learned counsel for the applicant, stop, also heard Mr. P. Borthakur, learned APP for the state respondent. This application is filed under section 431 of the BNSS 2023 for suspension of sentence and for allowing the applicant to remain on previous bail during pendency of the revision petition. It appears that the petitioner was. There's also notice
Basically, what is the very.
you've been convicted.
Yes, but the thing is that madam, they were during the trial, madam, they were on bail, madam. And madam,
Mr. Das submits that during the trial, during the period of trial, the petitioners were on
Bail.
bail and had also cooperated the trial. Stop. And accordingly, he seeks direction for allowing the applicant to remain on previous bail during pendency of the revision petition. Mr. P. Borthakur and APP for the state respondent submits that there are no materials on record. That
only because he is in
that submits fairly that since he had been in bail during the trial and has not done anything to hamper the trial, the prayer may be considered. Accordingly, the applicants named I. Kondrapur Kyot and Hitesh Khatonia are allowed to remain on their previous bail during the pendency of the connected criminal revision petition.
suspended.
That I'm not doing it now.
I did.
I'll dispose it of.
Fine.
The IA accordingly stands disposed of.
Lordship, the matter relates to negotiable instrument act, my lord. The CJM wrongly, the convicted the persons against which the petitioner has filed an appeal before the session court, my lord. Now, my lord, pendency of this criminal appeal, my lord, the one order has been passed, my lord, without allowing this petitioner to file a written objection, my lord, in the petition filed by the respondent, my lord. Lordship, kindly have a look at
Which is the order at page?
it's in order, Lordship, page 35, my lord,
Page 35.
35. 16/12/2024. Just I'm reading out, my lord.
Yes, yes.
Content. Today is fixed for filing objection of the appellant in respect of the petition number 2630/24 filed by the respondent. The aforesaid petition number 2630/24 was filed by the respondent respondent on 7/9/24. And copy of the same was served upon the learned counsel for the appellant. However, in spite of granting appeal, so ensure appropriately to the appellant to file objection, the same has been filed today. Today also seen petition number 3827/24 filed by the learned counsel for the appellant stating therein that the senior leading counsel is ill and another date may be fixed for filing objection and for objection hearing on the aforesaid petition number 2630/24. However, the other counsel for the appellant who has filed the petition is absent on repeated calls. My lord, one junior file on his behalf, my lord, because the leading counsel was ill, my lord.
Mr. Chetri,
Lord.
it appears that several occasions have been granted
No,
despite that
This
objection
is,
was
my
not
lord,
filed.
only one
Uh,
time, my lord, it was allotment. Subsequently, my lord, when this case came, my lord, this totally this case, my lord, this NIC, this NI Act, my lord,
This
this based on
petition,
fraud, my
the
lord.
petition which was filed is for allowing you to file objection.
Lord,
The petition number 2630/24.
yes. And
That
I
is-
have filed the
That is
petition,
seeking prayer for filing objection,
yes,
and that was rejected.
yes,
And that order you have challenged.
yes.
Now it appears,
Now,
Mr. Chetri, the only thing is that there is no difficulty for issuing notice. But if you are seeking for a stay of
no,
this
other-
order,
otherwise
I am
my-
not
my
inclined.
only.
I'm not inclined to stay
No,
this order
here,
because
my
you
lord.
see, so the order records the reasons for refusing. Now you are
But,
before this is under revision, you have filed a criminal petition. Now, before this court exercise inherent power, this court has to see what is the error that has been committed.
Yes, my
Now,
lord. Here,
this court is not
here,
exercising the
only,
jurisdiction of an appellate court, correct? Now,
Here-
it appears,
here I have, in earlier occasion, I filed a criminal revision petition, my lord. Then after going through the 397(2) provisions, my lord, I have to file this criminal.
maybe
petition.
I'm not dismissing your petition, but
No,
I'm saying
here-
I'm not going to
Then,
give you,
then lordship will come.
I'm not staying it.
No,
I
my
can
lord,
give you a
lordship,
short date.
I have been told, my lord, this lastly, lord, 36, lord.
Hmm?
Case 36.
Yes,
Yes, sir.
Yes.
I've gone through the judgment and order so and so, so also seen petition number so and so. I have heard so and so, joined the record so and so. See, section 148(1) of the NI empowers the appellate court to direct the appellate to deposit such sum, which shall be minimum 20% of the fine or compensation awarded by the trial court. Section 148(2) of the NI provides that the amount referred in section 148(1) shall be deposited within 60 days from the date of order or within such period not
I don't
exceeding.
find any, I've seen the direction,
here-
one
here-
lakh 10,000.
My lord, the petitioner is a old lady, retired employee, my lord.
Sorry,
And she doesn't have the
Sorry.
money. And my lord, here, whole.
I'm
matter-
not staying this order.
No, my lord, here, my
It's
lord,
it's a discretion of the
Then-
court. You have not
then
really, yeah,
let the.
I can keep it open.
No, my
I
lord,
can keep the, yes,
no, let the, my lord, remand the matter to the session court to hear the afresh matter, my lord, on this issue, my lord. That will,
My lord, otherwise, but otherwise there is specific provision under section 148 of the NI.
That too. since whole matter depends on.
why should this court direct them to rehear the matter when the court is not convinced that there is any error apparent on the
My lord,
record,
here,
on the order?
error apparent, my lord,
Sorry.
it's a case of fraud, my lord.
I can issue notice, keep the interim open. It's your option. Or I'll dismiss it right away.
My lord, since whole matter depends on the fraud matter, my lord, that is why. My lord,
That is why I'm not
Yes.
dismissing it.
case
I am
is-
giving you the option.
my lord, only, the
I'm
fact-
not rejecting your interim today also. I'm keeping it open. I'll give you a short date.
to-
Heard Mr.
to-
B. Chetri, Leonard Counsel for the petitioner, stop. Also heard Miss, are you there in this matter? Because I don't see your name.
Otherwise, 138 NI.
But, you are otherwise made a party. Also heard Mr. P. Bhattakur, Leonard APP for the state respondent. This is this application is under section 528 of the DNSS and 482 of the CRPC 1973. Okay, 482. For DNSS Pulana for quashing of the order dated 2/12/2024, passed in criminal appeal number 3 of 2024 which is pending as on date, whereby the learned session judge Dorong Mongoldoy directed the applicant to deposit 20% of the compensation awarded by the trial court as provided under section 148 of the NIA, that is rupees 1,10,000 before the court within the period of 60 days in terms of the petition number 2630/2024 filed by the respondent, namely, not filed by the respondent, full stop. 60 days is over. After that, you have come.
No, before that I came, my lord.
No,
This-
this petition you have filed within 60 days or after 60 days? After 60. It appears that after the expiry of the period of 60 days, as directed by this court, as directed by the trial court,
Yes.
uh,
It's appellate court.
appellate court for depositing the aforesaid compensation, comma, the applicant approached this court by filing the present petition with a stay prayer. Stop. Third, issue notice. So and so except for the are to step by registered post within 3 days. The prayer for interim is kept open after the return of prayer for so and so shall be considered on the returnable date. Released after 3 weeks on a date to be fixed by the registry. Mr. Chetri, for a moment, I thought I will stay. If you would have come within 60 days, I would have stayed it. But you
No,
came
that
after.
matter, my lord, I must say, my lord, this criminal division petition was filed.
Anyway, yes, Mr. Bora,
And the lordship. So for lordship, is the daily wages labor, my lord. So there is a FI was lost and my lord, thereafter a summon was issued and petitioner was appeared before the trial court, my lord. And in the meantime, COVID-19 is coming and therefore non-communication by the advocate as well as my lord.
now warrant has been issued and
And my lord, one thing is that complainant already expired, my lord. And so my lord, he is not coming, so he is been going to Chennai for the purpose of security guard, my lord. So he is coming
Earlier you
now,
were
we are
on
going to
bail.
appear, madam.
earlier you were on bail.
I am on bail, madam. Bail, madam. Please may kindly see.
About
Please.
this, I think we can dispose
Dispose
it
of
in the
matter.
direction that let him appear and the court will consider.
He shall appear, my lord, in all subsequent dates without bail.
So let the court consider all that. Why should we grant him anything here? We'll dispose it
Till then.
till then. We'll fix a day. Only
Fine.
till then you shall not be arrested.
Fine.
And it is after that it is open for the trial court.
My lord, 498 already expired, my lord, complainant. Complainant already expired.
Trial court decide. Trial court is already seen. You have been not appearing before the trial. court.
I am. I'm
Which
going
is
to
the order?
stand up, my lord,
Which is the order?
page, my lord, page 24, my lord. The 4/4/2022, as well as my lord, 6/11/2024. And 27/2/2025. Your honor.
Earlier also you were absent, no?
24 and 26.
No, the first order is 4/4.
4/4, my lord.
And then
4/4/2020.
6/11.
Next 6/11/2024,
And
warrant of arrest was issued.
and
And
then
next, my lord, PNR, my lord, I am declared as, my lord, abscond.
27.
27. Allowed to appear, my lord. Allowed to appear.
Heard Mr. N. Bora, learned counsel for the petitioner. Stop. Also heard Mr. P. Bothakur, learned APP for the state respondent. This application is filed under section 528 of the BNSS 2023, seeking quashing of the orders dated 4/4/2023, 6/11/2024, 27/2/2025, and all other subsequent orders passed by the learned JMFC number 1, Nagaon, Assam, in PRC case number 624 of 2019, by which non-bailable warrant of arrest, order of proclamation, and order of absconding respectively was issued against the petitioner. Full stop. Mr. Bora submits that due to the non-COVID breakdown, the petitioner lost contact.
Right.
The petitioner lost contact
Yes, oh yes, petitioner lost contact as well as
With
the
the-
COVID-19. And
with the that, facts of the case.
para number 4, my lord. After lockdown was
One
lifted,
second.
para number 4, page 5, my lord, middle line, my lord.
Facts of the case is that the wife of the petitioner lodged an FIR on 6/9/2018 at Kanpur Police Station under Nagaon district, which was registered as Kanpur PS case number 230/80 under section 498 capital A/494 IPC, alleging inter alia that the applicant, that the petitioner had what is the contents of the FIR?
Page 14, my lord, the married to, and after marrying her, started torturing me and physically and mentally by.
Alleging inter alia that after the marriage, the petitioner started torturing her both physically and mentally and also demanded money. So accordingly,
Mother
case
and
was registered. Thereafter, charge sheet was filed and the trial
someone was issued page 18, my lord.
trial started, isn't it?
Yes, yes. Someone was issued on 22/11/2000, page 18,
And thereafter, the
remain on bail.
after registration of thereafter a case was registered under section 498 capital A/494 IPC before the magistrate court, whereafter summons were issued against the petitioner and the petitioner appeared and was allowed and was also released on bail, and accordingly the trial commenced. It appears that the petitioner appeared on the next day, appeared before the trial court. However, after the breakdown of coronavirus, there being lockdown all over the country, the petitioner who was working as a security guard at a private company at Chennai
My lord,
during that time
my lord.
could not come to the court is at not could not come to Nagaon on the next 3 subsequent dates. And thereafter, and full stop. It appears that after the lockdown was lifted and the case was fixed on 18/1/2021. Neither the petitioner appeared before the magistrate court nor any steps were taken. It further appears that on subsequent dates as well, I 12/3/2021, 12, 12, 28/5/2021, and 1/9/2021. Also, since there was no since the petitioner did not appear, notices were issued. Notices, fresh notices was issued to the petitioner. It appears that because of the continuing non-appearance of the petitioner, the magistrate court, by orders dated 4/4/2022 and 6/11/2024, issued NBWA and proclamation against him. NBWA against him. First you say 4/4/2022. It appears that the proclamation issued against it appears that since the NBWA issued against the petitioner returned answer, the magistrate court on 6/11/2024 reissued proclamation against him. Returned answer with a report that he couldn't be found. Thereafter, on 27/2/2025, the proclamation having returned with a report that the same was properly executed, however, since the petitioner was absent, the magistrate court was pleased to declare the petitioner as absconder and was further pleased to issue standing warrant against the accused. Against the aforesaid orders of the magistrate court, the present criminal petition is filed. Mr. N. Bora, learned counsel for the petitioner, submits that since the petitioner was staying outside the jurisdiction of the state of Assam, and in connection to his work as daily as a security guard in at Chennai, he could not come during the lockdown period, and after the lockdown period was over, his wife expired and he has also lost contact with the lawyer who was, you have stated this?
Yes.
Who was appearing, who had represented him before the magistrate court, for which he was not aware of the subsequent dates. He further submits that the petitioner is ready and willing to cooperate with the trial Mr. So and so learned APP fairly submits that considering that the petitioner is ready and willing to cooperate cooperate in the trial, comma, the petition can be disposed of with a the petition can be remanded back to the magistrate court for taking for deciding for deciding
They have to pass appropriate order.
for passing appropriate orders in accordance with law. Stop. Heard, Perus Puritima. This paragraphs, explanation paragraph starts from
That's from page 5, paragraph 4.
the other part. The
Other
first
part.
part I've already dictated.
My lord, security guard, para 6, and a wife, wife was expired, para 5, and he was not aware, para 7.
Hmm.
Which is still
Para,
paragraph 7, ma'am. After lockdown was, he said, court reopened the 15 months ago, but he was not aware of any period.
relevant paragraphs, apt to refer to the relevant paragraphs of the petition in support of the prayer made therein. Quote unquote 5, 6, 7, 8. It appears that the petitioner is that the petitioner was initially appearing before the trial court on all dates. However, after the breakdown of COVID virus, he has failed to attend the subsequent dates of the trial, for which ultimately the orders of NBWA and standing warrant against him had to be issued. NWA, proclamation and standing warrant issued respectively. Be that as it may, this court for the ends of justice, without going into the merits deem appropriate to remand the matter to dispose of the petition with a direction to the magistrate court with a direction to the petitioner to appear before the magistrate court within, I think a date probably is fixed, but we don't know,
29th of April.
29.
on 29/4/2025. And upon such appearance, the magistrate court shall pass appropriate orders in accordance with law. It is needless to be clarified that till 29/4/2025, he shall not be arrested. The petitioner shall not be arrested. However, I have already said till so and so. I think that is sufficient. If you want to say something, Mr. Bhattato, please do. Anything you want to add? No, ma'am. With the aforesaid direction, the petition stands disposed of. Anything? No, I have not. I have only said you will not be arrested. And then once you appear there, the magistrate shall take a call in accordance with law. I think since I have already fixed it, so there need not be any intimation from the registry.
No, but no, I will place the order.
Or should I say the registry also to communicate? Let the registry communicate the aforesaid order to the so and so court, so and so, huh?
I don't know.
Disposed of. Yes, Mr. Day. Oh, sorry, Thakur.
Lordship, here we have your lordship, change the order for coming charge.
Hmm?
Order of
Payment
coming
charge.
Your lordship, before your lordship, want to be.
Charges
order of
are,
coming charge, your lordship, there is an order in the bail application filed by the present petitioner. The matter of bail as well as this may be taken up together.
bail is not there today. Not there. So we'll direct this to be listed on another date. Mr. S. Thakur, learned counsel for the petitioner submits that
Take the order. What is?
submits that this court by order dated 24/3/2025. No, submits that a bail application being bail application 823 of 2025 in connection with the in connection with the issue raised in the revision petition is pending before this court, and this court on 24/3/2025 directed the said bail application to be listed along with the instant criminal revision petition. However, today, when the criminal revision petition has been listed before this court, the bail application is not listed along with. In view of the above, let the criminal revision petition be listed on such and such date along with bail application number 823 of 2025.
Friday. Your lordship, this is the criminal petition, not criminal.
Sorry, criminal petition. I think in that order it is mentioned revision.
Thank you.
Then appears for the petitioner on call, list after 2 weeks on a date to be fixed by the registrar. Thakur appears to be. Yes.
That is a lot.
Yes.
Madam, this is an application under section 528 of BNSS, madam, for passing of a proceeding, madam. And,
This had earlier come
no, madam.
once.
Well, that the matter was listed, but the council was not present, madam. I have the adjournment, madam. So my case is that, madam, the respondent has instituted a petition against the present petitioner under section 125 of CRPC. And the said proceeding has been pending before the principal judge Borpeta Family Court, madam. Here what happened, madam? Madam, before perusal of the record, madam, may I submit, madam, the facts of the case, madam? Here what happened, madam? On 5/12/2020, the petitioner and respondent, they solemnized their marriage before a notary officer by executing a minor,
You are seeking for setting aside which order?
minor the entire proceeding, madam.
At this stage, you will not
Madam-
get an interim. I can keep your interim open.
My submission is that, madam. What happened?
I can keep it after Bihu.
My submission is that, madam. The one must come to the court with clean hands.
All right,
Get the equitable
the respondent is not here, ex parte, we are not going to stay anything.
Madam,
Uh,
the respondent has filed this case, madam, by suppressing and concealing.
This
the
is
fact.
what you are saying.
It is on record, madam, that they have made some statement in the.
Where is the complaint?
Madam, start from page number 22, that is the type copy, madam. Annexure 4. And the original complaint is start from page. number-
Allegations are all there.
Madam, my submission is that, madam,
You want me to reject your interim today or you want to,
madam,
You want, or you want the consideration of the interim after Bihu, after notice?
My lord, pass.
Which one?
After Bihu, my lord, my submission is that, my lord, I have another interim prayer, my lord.
Huh?
Another interim prayer, second interim prayer, that Lanet Court below, my lord, has passed an order to pay a maintenance amount of rupees 3,000 to the respondent, my lord. May I beg for a lordship, my lord, that amount may be reduced till the returnable date.
No, nothing doing, 3,000. Nothing doing. On that day, you make that prayer after she appears, and if required, it will be reduced,
My lord,
but not right now.
my lord, another prayer-
Sorry, Mr. Hussain.
my lord, DJ Halloy, my
Halloy. Sorry, Mr. Halloy.
my lord,
Heard Mr. DJ Halloy, Learned Counsel for the petitioner. Uh, This is an application under section 528 of DNSS within bracket, DNSS 2023, read with article for quashing of a proceeding being number FC within bracket criminal case number 214 2021 filed by the respondent under section 125 of the Code of Criminal Procedure against the petitioner. Which is pending before the learned principal judge, family court, Borpet. Mr. So-and-so, no, issue notice, returnable date detailed after the on such and such date. Steps by registered post within 2 days, Mr. So-and-so, Mr. So-and-so Halloy, Learned Counsels seeks for reducing the monthly maintenance allowance to rupees 1,000 per month instead of rupees 3,000 as directed by the learned principal judge, family court, Borpeta by order dated 17/8/2024, passed in FC within bracket criminal case number 214 of 2021. Stop. Let the aforesaid prayer be considered after returnable date.
My lord,
On the returnable date.
my lord, court below, my lord, that business warrant was issued, my lord. That
Yes.
is equal, my lord.
Sorry,
Business warrant was issued. I was absent for 1 day, my lord. That may be recalled. I will appear before the court.
that
below,
is
my
not there in your prayer.
I have,
in
I
the- No, I'm not doing all this. We should have appeared. Yes,
lord. Anyways, item number 5, so I did not follow. I was just sitting there. Item number 5.
you were not there when it was called.
I was there, so I could not.
You did not hear. Queen Maista 5. Charge sheet. Washing of charge sheet and order. A notice.
Civil dispute, constitute breach of contract.
Where is the company?
FIR,
FIR?
page number 13, lord.
Which number?
Page number 13. Both the parties entered into an agreement for construction. The informant is a contract.
All right, read.
I am hereby informing you that on 11th July 2018, I came to an agreement with Mr. Sudeep Bose of Shillong, Meghalaya, and Mr. Supriyo Naha of Rehabari, Guwahati, for development of a project on their plot situated near Kali Mandir Road, beside Manasa Mandir House and opposite of Ramkrishna Mandir Road, Birubadi, Guwahati now. Now the matter is Mr. Supriyo Naha failed to make the payments from January 2020 as per agreement.
Mr. Borthakur.
And due to
It
failure
is
of
an
payment-
essentially a civil dispute.
civil dispute,
Where is the order?
order of cognizance.
Yes, that is also under challenge.
Yes, it is also under challenge.
Yes, page 22.
Yes, I have annexed.
4064. Where is the ingredients of initial dishonest intention and fraudulent misappropriation? Sorry, liquor. I'm staying it.
Sorry.
You had such a strong case for interim and you were Not aware when the matter was called. Ah, you should have been sitting in the front and be alert. Your name? Heard Mr. F. J. Majumdar, Learned Counsel for the petitioner. Also heard Mr. So and so what happened, huh? For AP. This is an application under 528 BNSS 2023 seeking quashing of proceeding of PRC number so and so pending in the CJM Kamrup M and the impugned order of cognizance dated 29/11/2021 passed by the Learned Court of CJM Kamrup M in PRC case number 2585 of 2021. Issue notice returnable after 4 weeks and steps by so and so accepts so and so and registered post AD for R2 within 3 days. It appears that the respondent number 2 had lodged an FIR against the petitioner alleging inter alia that due to the breach of agreement contract that due that since the alleging inter alia that on 11/7/2018 he came into an agreement with Sudeep Ghosh is who?
Is an,
Who is Sudeep Ghosh? You are the petition. You are Sudeep Ghosh.
I am the Supiona.
With one Sudeep Ghosh and the accused petitioner for development of a project on their plot situated at Guwahati. Stop. It is further alleged that since the accused petitioner failed to make payment from January 2020 as per agreement, he stopped the work from February 2020 after completion of almost 80% of the work. And though repeated reminders were given for the payment, the accused petitioner did not make the payment. Instead, from 23rd December 2020, without informing him, restarted the remaining work by another contractor. Accordingly, the FIR was registered and was received and registered as Paltan Bajar PS case number 62 of 2021 under section 406/420 IPC. Now, it appears that thereafter the magistrate court, the jurisdictional magistrate court by order dated 29/11/2021 took cognizance of offences under section 406/420 of IPC against the accused petitioner. Perusal of the complaint as well as the cognizance order, it is clear that it is prima facie it is prima facie it appears prima facie that the magistrate court has taken cognizance of the offences under section 406/420 of IPC mechanically and without any application of mind. Inasmuch as there is no ingredient prima facie appearing from the FIR indicating dishonest intention and fraudulent misappropriation. That being so, the proceeding of the police report case number 2585 of 2021 pending in the Chief Judicial Magistrate of Kamrup M is stayed until further orders. It is needless to be clarified that the observed that the observations made herein above is only for the consideration of the interim prayer and shall have no bearing of the same at the time the petition is taken up for hearing. Stop. List after 4 weeks on a date to be fixed by the registrar. Yes, Mr. Gautam. Oh, this is that, which is this matter? This is that LGB RIMH matter. I shall not be able to take this matter. There has been some development. Hear out the order. Item number 6 and 7. 7. Heard Mr. N. Gautam, learned counsel for the petitioner. Also heard Mr. K. Gogoi, learned CGC for respondent numbers 1, 5, and 6. Mr. K. Fukan for respondent number 8. Anybody else?
Mr. Datta appears to respond.
Mr. A.K. Datta for respondent number 7. This matter, while this matter was heard by this matter, was hearing of this matter was going on before this court. And today was the next date of listing for further hearing. However, while the matter remained partnered before this court, a letter was received in my residence from an unknown person, whereby certain information as regards the matter has been furnished. It appears that along with a forwarding letter, such direct communication with a judge who is hearing hearing the matter is depreciated. It appears that this court, I have already brought the matter to the notice of the jurisdictional police station, and they have seized the letter with the envelope and is inquiring into the matter. That being so, it shall not be, I am not comfortable to go on with the hearing of this case. And as such, I recuse myself from this case. Let the matter now be released from Parthurt. Let registry list before any other bench without.
Possibly wanted, interim order.
I'm sorry, sorry, I have recused myself. I'm sorry. To approach the registry, get the matter fixed in the next 1 or 2 days.
Application. And it's a appeal is preferred challenging the judgment of order dated 17/2/25 and order of sentence dated 25/2/25.
There's a statutory appeal
Yes.
for Thakur.
Yeah, this thing notice has to go.
Yes, yes. Foxo. Heard Mr.
Miss answer.
M.H. Ansari, also heard
This is an appeal against the judgment and order of learned additional session judge Nagaon. Lordship impugned judgment is at page 22.
under
Lordship, I was convicted under section 324 and 307, Lordship.
appeal. I can, I'll allow, admit it, but what
Yes.
about
Lordship, I'm coming, Lord. Lordship, so far as 389 suspension of the sentence and allowing me to go on bail, Lordship, my submission is that there are total 7 witnesses, out of which one is IO, Lordship, and one is doctor. Except the PW6, the injured, none of the witnesses have stated that I have assaulted, Lordship. I would like
during
to.
trial were you on bail?
No. From the date of judgment, I'm in jail. Earlier, I was in jail for 37 days, and now it is another 20 days. It is almost 57 days. I'm in jail, Lordship. I would like to point out, Lordship, 2 things. Lordship,
1 second.
man,
You obtained an instruction?
Otherwise, only that prayer may be considered after receipt of the LCR.
That is what I was thinking.
Lordship, may I submit to you? Lordship, may kindly go to page number 63.
Where?
Page 63. It is the medical report, Lordship. The
The problem is, earlier you had a presumption, now you are convicted. The presumption is gone.
no, Lordship,
Isn't it?
Lordship,
Now,
just- Lordship,
I'm not rejecting your IA, but I mean,
Lordship,
calling for the records, and after receipt of LCR, your IA will be considered.
Lordship, just 2 lines, Lordship.
Sorry,
Lordship, the doctor has said that the injury is simple. Even the medical report as well as the evidence of the doctor, Lordship.
not like this. Criminal appeal, This is heard your name,
Darakunda.
heard Mr. Darakulal, Learned Counsel for the appellant, also heard for Thakur, APPM. This is an appeal under section 4152 of the BNSS 2023 against the judgment and order dated 18/2025 passed by the Learned Edition Session Judge number in sessions packet T2, case number 138 of 2016, whereby appellant was convicted under section. Sentenced to go rigorous imprisonment for 2 years and to pay fine of 5,000, undergo simple imprisonment for 1 month and also and sentenced to undergo rigorous imprisonment in default to undergo SI for 3 months. Stop. Admit. Returnable. Weeks, 3 weeks
Lordship,
Three weeks?
thought this may be.
in the
Lordship,
default
as I'm in jail.
on such and such date. We will present in video.
Yes, Lordship.
Going to accept notice on behalf of one, extra copies within 3 days. Respective registered post 80 within 3 days. I will list after so and so. In the I, the prayer, call for LCR, TCR, call for TCR, huh? In the IA, you say the prayer shall be considered upon receipt of the TCR.
Let me tell you. Public.
376,
376, 448.
and you have a IA also,
My lord. 10 years, they will anyway have to give objection.
huh?
10 years punishment, so they will have to give objection.
Appeal, I can admit,
Yes.
appeal है similar order did admission. Mr. H, Chaudhary, right?
But DK Bhattacharya, my name is not reflected.
Yes, that's why I got confused for a minute. Mr.
I'm assisting him.
You are assisting him. Your name is there.
I have.
You all need assistance. DK Bhattacharya. Counsel for the. This appeal is against the conviction and sentence under section 415 of the 415.
448 and 376. The appeal is under 415. DNS. That is the provision for appeal.
This appeal is filed under section 415 of the DNSS 2023 against the judgment and order dated 27/1/2025 passed by the learned session judge Lakhimpur in session case number 105 within bracket NL stroke 2024, whereby the appellant was convicted under section admit notice
For number 2.
admit going to accept notice on the one as regards to registered post AD. Where is the I? The accompanying I 320 of 2025 shall be considered after the returnable date. After the return of the returnable date. And list after 3 weeks on a date to be fixed by the registry.
Once upon submission, my name may be reflected. I have signed
Uh,
up, but I don't know.
Let registry reflect the name of Mr. DK Bhattacharya in the cause list. Of the appellant. Academy, Adiba, Urdu Academy. Forward.
May I please? Lord, I am
Yes.
for the petition.
What are you seeking here? Quashing of the magistrate court's order and the appellate court. And this is
My lord,
negotiable.
courts below, my lord.
Don't say, counsel, please refrain from saying the word below.
Hello.
Refrain from using the word below when you refer to the trial court and the appellate court.
My lord, the petitioner before your lordship was the complainant under 138 of the NI Act who filed a complaint case for bouncing of a check of ₹5 lakhs. But my lord, the trial court below, while passing, the impugned order was passed after observing that there was 1 day delay in filing the complaint case. And the impugned order was passed on 28/9/2016 at page 29, my lord. At page 29 of my petition, last but one, that there is delay of 1 day in filing the case. And hence, the case was dismissed. And my complaint case was totally dismissed. Thereafter, I preferred one revision. And the
One day-
revisional court also, my lord,
A mandatory time frame.
Hello?
Under the provisions of the act, it's a mandatory time frame. The time frame,
yes, yes, my
the
lord.
statutory
Under-
time frame that is
Under 152,
provided
my lord,
for
for
filing
filing
the
the case.
complaint. Admittedly, you are 1 day late.
As per both the courts below, but there was in fact no delay at all.
But you see, you are
That is
now
why I am
before-
standing before your lordship.
But you see, you are before the inherent jurisdiction. Now, court will not go into the factual aspect. Both the courts have recorded a finding of fact. This is the third court.
My lord, they have completely, there is manifest error on the part of the court below. That is why I am before your lordship to see the legality and the
What
validity
is
of the
the error?
findings.
What is the error?
Yes, my lord.
They have recorded
my
a
lord, there
finding
is-
of fact.
My lord, my lord.
See, they have recorded a finding of fact that you have been
But
one
based on
day-
legal things, because the section 142 of the NI Act says that complaint case is to be filed after, that is from the date, within 30 days from the cause of action arose. Here, both the courts below have committed wrong calculation as per the guidelines of the Honorable Supreme Court and as provided under the
Alright, I'm
Limitation Act
admitting
also.
this and fixing it for hearing. Will need hearing.
Yes.
Heard Mr. A.K. Jain, learned counsel for the petitioner, also heard Mr. D.K. Haloi, learned counsel for the respondent. So, the matter requires a full-fledged hearing. Admit list for hearing in the month of May 2025. No formal party visit. Yes. Orders? What about the bail hearing?
Wait, please, Alok. But you have an amicus in this matter.
Yes,
As per the last order,
yes.
a report was sought for from the jurisdiction.
Yes, Mr.
jurisdiction.
Bhattakur.
And I had a talk with Miss Bora, who was the PP the earlier time, but she said she has not received any order from the
Await for the report as called earlier by this court by order dated 4/3/2025 as regards whether the petitioner has served the sentence or not. List after 2 weeks.
Obliged.
Or a date to be fixed by the registry. Third, D.K. Bhattacharjee, Parent. Bhattakur.
hearing.
PD
Item 19. Can we call for?
and DPS.
Arrest is not done as per law, my lord. So I am protected under Bihans Kumar and Ashish Gupta. The certified.
But that is an aspect which has to be considered during trial. This is NDPS
My lord, the large numbers of cases.
37.
Yes.
Is what section? NDPS,
And the cedars.
huh?
Cedars.
C is there. Then 37, the regards at this moment. How can this court go into all these questions whether how the arrest was done and not? These are things which will have to finally come out in the trial. My lord, the arrest is, when the arrest is itself illegal, my lord, the fundamental rights of the petitioner is violated. That is something you can also argue at the trial stage. How will the court, why, see, this is under NDPS. The rigor of 337 will apply. If it is seen that you have committed. My lord, I am filing additional affidavit in this respect. You want to file? Yes, all right, fine.
In this case, also the affidavits, LCA has been confirmed.
And then in the meantime, you call that. Mr. Mr. H.R. Chaudhary, learned counsel for the, for the petitioner seeks 2 weeks. One is, but he has to get the updated 2 weeks time to file an additional affidavit in the matter. Prayer is allowed. In the meantime, let the updated, scanned copy of the TCR be also called for. Did you have date after 2 weeks, list on such and such date? Right.
May I please, your lordship. Lordship, consider matter, lordship.
There also lordship affidavit series request on last, it is affidavit till
Alright.
27.
Lordship, here
Get
also,
it updated, I'll fix it immediately. When? Friday?
Because affidavit, LCA will come.
lordship, already NCR is up to date. I have gone through the.
After 27, you have got any.
Mr. Lawcore is not going to make unnecessary submission into this court. EP and the court has high regard, submission made by the AP. Don't make all this, because you see, you cannot be privy to the record. How have you seen the records?
I have gone through.
Don't make all this submission. Item number 20. Let the,
Lordship, I have a humble submission. Lordship, here also the mandate of 47-48 is not followed. And there is judgment of NDPS, there is judgment of a coordinate bench.
let's see it on the next day. Let the updated case records be called for, list on such and such a date.
Lordship, may kindly allow to file an affidavit.
And in the meantime, petitioner is at liberty to file an additional affidavit.
Registry will call for the affidavit. Registry will call.
I said, let's call through registry. Okay? Wait. 21. Yes,
21 commercial quantity of heroin, my lord.
yes. You have the scan copy?
Yes.
Yes.
My is another court. Take this matter up for some time.
In this case, lordship, final complaint is made by not third of April. CPA, commercial quantity of.
FR has been filed.
Yes, final complaint.
Closed.
Lordship,
Final,
final complaint.
final complaint, I heard. Social.
Case number is 25 and 95 of.
Applicant is not here.
Yes.
Another date? None appears for the petitioner on call. Heard Mr. So and so, and then it,
For DRI.
then it D, RI, standing council DRI, huh? Relist, deliver date after 2 weeks.
My please, lordship. Lordship, Angus counsel is in another court. Matter was taken after.
Yes, affidavit.
Charge sheet submitted, but let him come.
There also minor arrest. I'm challenging arrest.
Procedure.
Yes.
You want to file additional affidavit?
Yes.
Heard, Mr. H.R. Chaudhary, learned counsel for the petitioner, seeks some time for filing an additional affidavit. Stop prayer is allowed. Yes, updated or it is already there? Read.
Proceed with the apparatus.
Before, okay, list on 11, immediately opening 11.
11th, before. 11th,
Okay, okay.
11th.
Obliged. Yes, Mr. Manan, C is also there.
I cannot really have to consider instead of.
Huh?
We have to consider
We
LC.
have not gone through. And tomorrow. Tomorrow, Mr. Manan? As prayed for, list tomorrow. No, no, we say Mr. Y.S. Manan, heard Mr. Y.S. Manan, then comes from the petitioner, Mr. P.S. Locker, APP from the state, seeks accommodation for the day, S, in order to go through the, what, scan copy of the case records. Prayer is allowed, release tomorrow. Such and such date. Isat Maridipurnigi? No? Receive. But we'll wait for some time because petitioner may come. Yes, 29.
Same, quickly with application. At the direction of this one, court, application for the penalty document. This statement of reported. From last together, I submitted the post. But if till date, we didn't find any evidence against it. What should be considered?
You have filed a report, filed an affidavit.
Yeah. No, what's it report?
Where is your report? You have not found any material.
Till date, we didn't find any evidence. Because what notice was 200 section 7. Fortunate, paragraph 8.
The offending vehicle is, was initially owned by whom?
Petitioner,
Petitioner.
but
And
he self sold out that
he
vehicle.
sold it to one Ganpati
Ganpati
Motor.
Motors. On 6/4/2024,
And the incident happened thereafter.
thereafter 27/9/2024, after 5 months.
Actually, only provide that whenever is required, he will appear.
Item 29. You heard Mr.
Hey, how are you?
A. Hawari, Learned Counsel for the petitioner, stop. Also heard Mr. S.C. Kyle, Learned Standing Counsel, NCB. Stop. This is an application under section 482 of BNS 2023, seeking grant of pre-arrest bail to the accused petitioner, I. Taha Alam Kandar, who is apprehending arrest in connection with NCB crime number 09/2024, read under section 8C, read with section 22C and 29 of the Indian Act 1985. This court on 14/2/2025 after hearing the matter, was pleased to direct was pleased to grant interim pre-arrest bail to the petitioner. It appears that pursuant to the aforesaid pre-arrest interim bail, comma, SCKL. It's SCKL that it so and so submits that pursuant to the pre-arrest interim bail, the petitioner appeared before the investigating officer. And his statement was accordingly recorded. He further submits that during investigation, no adverse material has been collected against the accused petitioner. In connection, in support of the aforesaid submission, Mr. Kal places the report received from the Inspector NCB Guwahati dated, where is the date? 24/2/2025, which reads as hereunder. No, which indicates that there is no adverse material available against the accused petitioner. That being so, the interim order passed earlier tense is hereby made absolute. It is needless to be clarified that the petitioner shall cooperate with the investigation and appear before the investigating officer as and when called. Anticipatory bail application stands disposed of. A copy of the report dated so and so furnished by Mr. SCKL and SC NCB is kept on record and marked as X. Rupak, it is X marked for you.
Item number 1.
I'm sorry, but I was not.
No problem. Yes, Mr. Datta.
Yeah, but it's the regular bail, my lord.
Yes.
The petitioner was arrested on 9/5/24. Subsequently, my lord, charge sheet was laid, my lord, citing, my lord, 8 number of witnesses. So your lordship will see the forwarding report, my lord, at page 12, my lord. 1.
Yes.
Now, my lord, the second page, my lord, page 13, my lord. Lordship will see the ground of arrest, my lord. The accused person have been arrested under the following grounds. The accused person are apparent person. During investigation, 30 packets of suspected heroin marked as P1 to P3 weighing 0.347 grams within bracket 347 grams without soap cover, 30 numbers of empty soap cover, 1 Alco K10 card, so and so, my lord. During investigation, interrogation
You are
period,
reading from where? Brief of the case.
my lord, page 13, my lord, 1.
Yes, sir.
One of the
During
grounds of arrest. Lord.
Yes, please.
Madam. Number 2, my lord, during investigation, total 30 packets of suspected heroin marked as P1 to P30 weighing total 0.347 gram within bracket 347 grams without soap cover. Number 2, 30 numbers of empty soap cover, 1 Alto K10 card bearing registration number AS01 so and so, my lord. Third, my lord, during interrogation period, the arrested
So
accused
this was taken from your possession.
Yes, my lord. Now, my lord, I'm coming on the law.
Possession is prima facie established.
Yes, my lord. Now I'm coming on the law point, my lord. My lord, this case was, my lord, registered with CRPC. If your lordship takes the CRPC, my lord, section 50, my lord.
That is the procedural.
Yes, my lord.
The apex court decisions are there. These
Yes.
are matters which has to be taken care of during trial.
No, my lord. My lord, I will cite one decision of the apex court, my lord, where it says, my lord, if, my lord, the arrest is initiated.
which is
My lord, section 50, my lord, of the CRPC.
50.
50, my lord.
Yes,
My lord, may I read, my lord?
yes.
Person arrested to be informed of grounds of arrest and the right to bail. Every police officer or other person arresting any person without warrant shall forthwith communicate to him full particulars of the offence for which he is arrested or other grounds for such arrest. Number 2, my lord, where the police officer arrests without warrant any person other than a person accused of a non-bailable offence, he shall inform the person accused that he is entitled to be released on bail.
You
and
are
that
not informed.
I have been not informed, my lord.
This is one of your grounds.
That is the sole point, my lord, in this case, my lord.
This
And
is
the
the only ground you are against.
yes, my lord, and the length of detention is also there, my lord. Now, if a lordship takes the LCR, my lord,
One
I-
second, one second. Doctor, I'll just come back in 5 minutes.
arrest should be
That
communicated.
I have seen.
Yes,
What
in-
authority are you carrying?
My lord, here, my lord, from the LCR, my lord, the section 50 notice is there, my lord, but no grounds have been given.
Where, what is the authority?
Authority, my lord, I have
At the time of, at the time of trial or,
at any period, my lord, during the, that's the,
because there will be a lot of decisions that the
Yes, ma'am.
trial get vitiated.
yes.
I am not on that.
We are not on trial, my lord. Our lordship, we have turned to paragraph 14, my lord, 1/4. 1/4, that is page 10, my lord, page 10, my lord. Wherein,
Yes.
thus the requirement of informing the person arrested on the grounds of arrest is not a formality, but a mandatory constitution requirement. Article 22 is included in part 3 of the Constitution under the heading of the fundamental right. Thus, it is the fundamental right of every person arrested and detained in custody to be informed on the grounds of arrest as soon as possible. If the grounds of arrest are not informed as soon as maybe after the arrest, it would amount to a violation of the fundamental right of the arrestee guaranteed under Article 22(1). It will also amount to depriving the arrestee of his liberty. The reason is that, as provided in Article 21, no person can be deprived of his liberty except in accordance with the procedure established by the law. The procedure established by law also includes what is provided in Article 21.
This is in reference to what case?
This is reference to, my lord,
PNSS,
yes, my lord, PNS,
not NDPS.
not,
So
now-
there are decisions in connection with NDPSs. I think that's Chandrachud's decision. Are you having that?
my lord, right now, not, my lord.
Then I can have it tomorrow.
Yes, my lord,
You get hold of that decision.
yes, my lord.
On NDPSs, because
Yes.
you see 37 is there.
Yes,
And what is to be considered at that time?
Yes.
It's been very nicely laid down in that decision.
yes, my lord. But so far, another case, my lord, which I am having today, but tomorrow I'll submit, my lord, that is also a UAPA case, my
NDPS I want
lord.
there because there I have,
Yes,
I
yes, ma'am.
remember there is a decision and I think based on that decision, I had also given one judgment,
My lord.
perhaps pertaining to the Aizol bench.
Fine.
Where also the similar section 50, then that 40, the procedure of Caesar, a lot of things were argued.
Yes, my lord.
And I had
Fine.
thought, I said, these are
Fine.
things which could have been argued also at the time of trial by following that decision.
Fine.
Because it has laid down as, because when one is dealing an application under 37 NDPS Act, then the consideration is different. That is what, you have a look
Yes.
tomorrow, day after tomorrow.
Yeah.
As prayed for, relist day after tomorrow.
I'm offering. I'm sorry about the other.
Yes.
If it lost it, whether it has come in the.
Oh, yes, it has come. Yes, what did you bring?
Commercial quantity lottery, NDPS Act. He was arrested on the basis of the
What was not explained?
for the 75 kg.
What was your ground, according to you, procedure violation?
No lottery. That is the
You have Justice Chandrachud's decision.
lottery.
Finally,
Similarly, lottery on same footing lottery, the statement of the co-accused lottery, the punching and the other lottery, the violation of the memos lottery that was not punished.
no, not this. There is one decision. This is a coordinate bench decision.
So, lottery. The Bihan Kumar lottery, is followed by Bihan Kumar and Probir Pulvasari. That on operative on third phase lottery.
Otherwise, my lord, I would like to point out, my lord, in the present case, my lord, was filed before filing of the charge sheet.
Sorry,
Yet the present bail application was filed before filing of the charge sheet. Now, my lord, charge sheet submitted in this case. So, while charge sheet already submitted, my lord, without getting any LCR, my lord, regarding those grounds
call for
taken. by-
Lottery.
Third, Mr. S. Munir, learned counsel for the petitioner. Stop also heard the PH Locker, learned APP for the state respondent. Mr. Locker submits that since pending the bail application,
Yes.
charge sheet has been submitted by its charge sheet number
That might be not kept as a part of the report.
right, DRG PS number 05/25 dated 31/1/2025 against the accused petitioner, comma. It would be, the scanned copy of the TCR would be essential.
Yes, that is very good.
The case the scanned copy of the case records along with charge sheet and
Yes,
case
that is
diary
report and case.
would be essential for effective adjudication of the bail application. That be so, let the case diary be placed. It will come with the record. Let the record be called for through registry, huh? And list on such and such date, reopening or all of this will be 29. It's gonna be upright, it is kind of. 28 to 1.
Much obliged, Your Honor. Much on.
None appears for the petitioner despite the matter being called twice. You have. When, Mr. Bhattakur appears for APP for the state respondent. We list after 3 weeks after 3 weeks on a date to be, after 4 weeks on a date to be fixed. by
Maybe
the-
allowed to return back the case. I may be allowed to return back the case.
In the meantime, let the case, in the meantime, the case diary receipt be returned back. And but it will be required,
Record what kind of 4 weeks, kind of keeping the case diary, kind of-
then we'll try next week. After opening. Till date. I didn't want to dismiss it today, otherwise this can be dismissed also.
But, my lord, one sense maybe only.
May it please your lordship. Lordship, my senior Mr. Jane Chaudhary is engaged before court number one, your lordship. Lordship requested some clarification regarding what is a domestic affluent. Affluent. Your lordship, my senior would be providing the same. May the matter be taken up after some time. Much obliged.
You please coordinate with, Mr., I think Mr. Burwa is appearing for
Yes.
pollution, right? So you both ensure that both Mr. Chaudhary and Mr. Burwa is there and we can, then close it. Okay, because only on that.
Lordship, after, yeah,
You try it for that.
we'll, much obliged.
Yes, what is this revision petition?
Here, Mr. Survey is repeating in this matter, but the instruction is here. The petitioner, the death certificate is divided by the department.
Are you aware?
That's not,
Petitioner died. Huh?
that's not true.
It can be abetted.
Seventeen, 14. 14.
Heard, MS,
S. Sharma appearing on behalf of Mr. B.K.
also heard MS,
LD.
L, N, and David, Senate Council for
For, on behalf of Mr. R.K. Chaudhary for the response.
you are not in the panel. On behalf of Mr. R.K.D. Chaudhary, learned, council for the respondent number. And for the
For one.
learned
one
Solicitor General of India. So, that council. That council for the respondent. It appears that this court had directed the respondent to inform the court as to whether the revisionist is still alive or not. Today, when the matter is called, MS so-and-so places the letter received from the Office of the Deputy Inspector General of Police, GC CRPF Guwahati, dated 26/3/2025, which indicates that with the no, which indicates that the revisionist I Pratyush Kumar Patra had expired on 7/3/2014. Along with the copy of the certificate of debt. And thereof. Copy of the said letter is kept on record and marked as X. In view of the fact that the revisionist petitioner expired during the pendency of the criminal revision petition, the matter stands in practice be abetted against swears. This is yes, Mr. Das.
Lordship, the Lordship had already heard the matter with regard to the evidence in the present case. Lordship, regard to the scene, I would now like to take the Lordships to the aspects of
findings of the trial court.
Mr. Bhattakur, you are, you are aware because on the last occasion, I think someone else was there. Was there?
But if I just. I think it's was fine.
Mr. Bhattakur, otherwise. You, can go ahead, no problem, but, today, all right, heard Mr. N.K. Das, Legal Aid Counsel for the appellant, also heard P. Bhattakur, learned APP for the state respondent. Mr. Bhattakur request, short accommodation in the matter in order to facilitate him to go through the case records. As on the last occasion, the matter was handled by another APP. Prayer is allowed. Yes, when do you want it? On 24th. Okay, released on such and such date.
But, Lordship, I mean, can it be after 25th?
Yes,
If it's confused, Lordship.
yes, yeah, date will be good.
Lordship. Deep different.
15 and 16. Pranav, 15 and 16. 13 is that matter. Right. Oh, yeah. You don't know, learn to that. Apart. Call them, call them.
But that is
Well, just bang it to the. Okay, like you know. Chaudhary wanted to. Think it is- You want to go and check? Could be outside.
I think our senior, your lordship.
Huh?
Maybe he's in some different court.
You
your
cannot
lordship.
find your senior.
No, cannot
But
able
I
to-
was told he will be here at 2. That's
Yes,
why I
yes,
have
yes,
come.
Yes, your lordship. We have informed him. Just
Oh,
give me some time, your lordship.
Then I will be.
only it is closed only with regard to.
Correct,
only
now,
have a clarification. I
I-
have made a brief note, Lordship.
Council,
We had a
my,
meeting actually. your lordship.
my
Maybe he's
board-
on the way. he's
my
coming.
board is over. Now, I am been told that my bench clerk was
Yes.
informed that both sides are ready at 2. That is why I have come out. Correct. If you have difficulty, you can always be accommodated, but it cannot be, I can do some other judicial work.
Lordship, my part
Tomorrow?
is complete, no, my part is complete. I have nothing more to add. Only I have made a brief note where also I have given some versions of the municipal act, which also needs to be read parallelly because the municipal act makes it very clear on what all buildings need consent. Because ultimately the parameters will be set by the pollution board. And unless and until we give them an NOC, they don't get the building permission. So that's why I have just noted down the relevant clauses. So if at all lordship goes to those, I think things will become more clear. And as regards CPCB, while giving the directions, they have only mentioned about building construction activities. They haven't mentioned anything as regards domestic or industrial. So construction activity comes under the parameters, and from that, we can all deduce the fact that sewage that is being discharged by both residential and commercial also comes under the ambit of concept.
So from where do you want this court to draw such presumption? From which part?
I
Not understood. This is like this note. Guwahati Building Construction Bylaws 14. You're referring to which one?
just going
Where will one find this additional requirement for multi-story in a special type of building? What kind of a note
The
is this?
space
I've not
for an
understood.
STP is mandatory to be proposed in the layout service plan and
Where are you reading from?
the last para of my
Last para. There's only one para only in the last.
second page.
The second page has only one paragraph.
Yes, that there only. There only.
Have you given a copy to the other side?
Yeah.
Anyway, you read first.
The space for a STP is mandatory. The space for a STP is mandatory to be proposed. in
What
the
is
layout
STP?
sewage treatment plant. And mandatory to be proposed in the layout service plan and construction as per the approved norms and specification in case of residential layout area measuring 4,000 square meters or more and IB group housing apartments houses if the build-up area measures above 2,000 square meters. Or if the consumption of water is to 20,000 liters per day and or if it is a multi-story building with more than 30 apartment houses.
Mr. Borwa, I'm slightly getting confused now. This that you are saying that these are requirements for the residential building in relation to sewage. This is provided under the Guwahati Building Construction Bylaws 2014. Under which provision? You have only mentioned some para 94. Para 94 is a provision. This is
I have to
If you are-
get hold of the end.
Or if you are relying on something, you must give it properly. Otherwise, how am I going to refer to all these arguments? I have not been able to make out anything from this note that you have given today. You see, you may have a point, but you have to place it properly. I have not understood. What is this para 94 in your note? From where is this para 94 coming? If the note that you have given, first you refer to section 25, then you say now, and then you go to the Guwahati building construction, then you say para 94. What is this para 94? You have to place all this if you want to draw home something.
It is not, it is the rule 94.
That's what I'm saying. You say, and why are you not giving the copy of the rules then? Wait, this note like the
No.
idea, you see, Mr. Borwa, the idea is to understand,
Rule I have given.
have
to South-
clarity in the matter, and then to offer the judgment. Because unless
I have given the-
unless the court has a clarity, it is difficult for the
Yes.
court to perceive either side of the argument. Correct? So I'm not being able
It's
to.
rule 94.
Okay, it's
Rule 94.
para 94.
Rule 94.
These technologies,
I have also.
you know,
given the
I
copy.
recollect something which my senior, when I had joined him way back in 2000, had said, there is no shortcut in this profession. One has to remember this for everything. Like you carrying those mobile phones, you are going on and see. But if you want to rely, you must have these rules in which you.
Now, why?
Why mobile phones?
No, in fact, let me come. While in this petition, why the petitioner has approached the court? Not because only we haven't given it. It's just because the DNC and DMD haven't given the permission, and that has been narrated in paragraph 13 of the petition, writ petition. So it makes it very clear the legitimate building permission occupancy certificate of the building above 3,000 square meters considered is a prerequisite. So unless and until they get a consent from us,
I have understood, but these prerequisites which you want to
and
impress are laid where? Where are those rules? What is that rule?
yes,
That rule 94.
Yes.
From your Guwahati Building Construction Bylaws.
I have given the proper. In fact, DMC and DMDA were. DMD and DMC were a party in this case. They were not present in.
They are not present, they are not present. This is your action that is under challenge. This matter cannot be, just because the other parties are not,
No, that part has to be taken care of by them because.
correct, but if they have not taken care of, we cannot force them to take, to do something.
That's why I was.
Now, you see, this matter has already been heard.
Yes,
I was almost ready to give the judgment. There was only one clarification that was required for which the matter was kept today. Domestic effluent. Because the meaning of domestic effluent is not there in any, in the statute. I couldn't find.
Nowhere we find.
Correct. So that is what you had
Nowhere we find.
submitted.
That's why I.
And Mr. Chaudhary wanted to make some clarification, and that's how the matter is
Yes.
today. Now you are telling me GMC lawyers have and all that. Do you have anything more to say?
No, I have only one thing to say is that while we were debating upon this section 25 as regard construction activities, so there nothing has been mentioned whether this is a commercial establishment or a residential. Then parallelly, if we go and have a look at the CPCB guidelines, directions that they have issued as regard the building and
So
construction.
where do I
activities,
find these guidelines? Which
Already,
page?
those are part of my.
Which page? If you want to assess the court, assess properly,
last-
you indicate in this note, then you make a brief note of the case. You give the points, give the paragraphs where the court will find all that.
I have given in a soft version, I have given today everything.
Soft version will not do. That's why I
Because
use the
those are
word
very
no
original.
shortcuts. You understand why I use that word? Soft version will not do. You must have, you are the counsel, you must have had an extra copy for the court. What is the soft version?
Let me have the hard copy. This ultimately, the CPCB also
The-
makes it clear. And while
That
we
is
were
the only
discussing.
reason I use.
Why-
Anyway, Mr. Chaudhary, what is that you want to?
No, my lord, I would just sum up as of what I argued. Basically, my lord.
Argument, let's not repeat.
Yeah,
I have
on the
understood
point
both
of-
sides.
On the point of domestic.
Correct,
effluent,
correct.
I could not find anything anywhere.
No, but if you see the Water Prevention Act,
Yes,
so why I am on this? Because ultimately, if this court has to construe,
yes.
Rule
No, my
twenty-five,
lord, trade effluent is defined.
correct. Now, see, this is,
Now, please come to G, to G,
before that.
sewage effluent.
Before that, do you have the Water Act?
Yes, I'm holding it, my lord.
Now, and the introduction,
Yes,
as a result of growth of industries and the increasing tendency to urbanization, the problem of pollution of rivers and streams had assumed considerable importance. It has become essential to ensure that the domestic and industrial effluents are not allowed to be discharged into the water courses without adequate treatment.
yes.
Then the statement of objects and reasons, then you see the act starts there also it is written, whereas it is expedient to provide for the prevention and control of water pollution and the maintaining or restoring and all that. Okay. Now, when we come to the definition clauses,
Yes,
G defines sewage, sewage effluent. It says means effluent from any sewage
Sewage
system or sewage disposal work and include sewage from open drains.
yes.
Then if you come to K,
K.
trade effluent. Mr. Borwa,
Yes.
please bear with us for a moment. Trade effluent includes any liquid, gaseous or solid substance which is discharged from any premises used for carrying on any industry, operation or process or treatment and disposal system other than domestic sewage. Now, see what, Mr. Chaudhary, I'm only trying to indicate the perception that is being drawn this side.
Can
You
I,
see,
can I?
one second, hear me out. You see, the object you have seen, it is
Yes.
for the protection of prevention and protection of the control of water and all that, right? Now, G defines sewage effluent. This appears to be both because trade effluent is defined separately. Now, when we come to section 25, it talks about subject to the provisions of the section, no person shall, without the previous consent or of the state board, establish or take any steps to establish any industry, operation or process or any treatment. Then there is an and.
Disposal
Disposal
system.
system or any extension or addition thereto, which is likely to discharge sewage or trade effluent into a stream or so and so. So these words and then or, you understand what is going on in the mind. That is where I have found a difficulty. And I thought, in all fairness, before penning it down, I thought of giving my perception before you both so that
My lord,
you
my-
can
can I respond?
clarify.
Yes. My lord, if we go by the rules of interpretation of statute, then certainly, my lord, lordship can take note of objects and reasons from here to understand what is the purpose. Secondly, my lord, trade effluent is an aspect that need not bother your lordships for the present. Because it qualifies by saying which does not include domestic effluent.
That is, there is no dispute.
Now therefore, whether G would come up, 2G, it says sewage effluent means effluent from any sewerage system or sewerage disposal work and includes surface from open drain. Now, my lord, when we read G with section 25A, what in my humble submission, my lord,
Yes.
or rather harmonious reading of both, my lord, it will not include a residential premise. It will include a premise where either industry or a commercial activity is being undertaken.
But what meaning would you give to the end?
And disposal system.
Yes. Because
And-
you see,
My
process,
lord,
comma,
and
or
because-
any treatment,
No, my lord,
and then it is
to-
separated
to
by the word
understand
and.
disposal system, we have to apply rules of use settings. There
That
is
is
no way
exactly
out.
what I wanted to do.
Yes,
Now, but there's a limitation there also,
yes,
that it should not be contrary to the object.
yes. No, my lord. Now that is the moot question. Now legislature in its wisdom has decided not to define domestic effluent, meaning thereby legislature did not intend to apply the restriction in respect of residential construction. More particularly, my lord, if your lordship will kindly come to this notification at page number 41.
Page number
41. It's a notification dated 14th of September 2006.
41.
Yes.
Yeah.
Please come to page 42 too. The following projects or activities shall require prior environmental clearance from the concerned regulatory authority.
Mr. Chaudhary, where exactly are you reading at page 42?
Page 42 on top. Madam.
Requirement.
Yes. Requirement of prior environmental clearance.
Yes.
The following projects or activities shall require prior environmental clearance from concerned regulatory authority, which shall hereinafter refer to as the central government in the Ministry of Environment and Forest for matters falling under category A in the schedule and state level, and at the state level, the State Environment Impact Assessment Authority for matters falling under category B in the said schedule. Before any construction work or preparation of land by project management, except for securing the land, is started on the project or activity. Now, my lord, will kindly come to the schedule. Now, at page number 45, my lord,
Yes.
on the second column, building and construction projects Now, building construction project, area development project township. 20,000 square meter, that is 15,000 square meter and built up area above. Only in this respect of those, my lord, Environment and Impact Assessment Authority has to certify, where all this, everything will come, my lord. Now, therefore, to meet the requirement of my lord, the requirement as is envisaged by the two impute notification, where from they are getting their authority. And when the act does not envisage something, can by executive instruction will not do that,
That's
number
not
one. And secondly, my lord, if you want to impose a reasonable restriction under 1912, number one, it has to be by law, and secondly, it has to be reasonable. No, it does not qualify in the either of the one. So therefore, my lord,
The other argument was that the 3,000 on what basis?
yes, they said
Alternate.
3,000,
Alternative.
yes.
Suppose we trace the power.
Yes. Now, my lord, now environment, pollution, air, water, these are all legislations under NP 97 of list 1. Because it is not either not specified in list 2 or in list 3.
Now, this you have argued. This
Yes.
is all right.
Therefore, my lord,
Maybe then, you see, if nothing else is there,
Therefore-
then why don't you submit a written argument?
okay, Rochester, give me 2-3 days
Yes,
time.
yes.
my lord.
But I would prefer if Mr. Borwa, you also submit your
Yes,
argument
yes.
and do it before Friday. I can fix it any date. I want to close it.
Okay.
Before the holidays. Otherwise, it will,
My lord,
I will forget.
I can give it on the Thursday. Yes,
Give it on Thursday.
yes,
I'm keeping the matter on Friday.
yes.
I'll keep it on Thursday or Friday.
I'll
Friday,
give it on
Friday.
Thursday, my lord.
I will submit by Thursday, let it be on Friday.
Both of you try and give it to the
Wednesday.
bench clerk
Court
on
master.
Thursday, so that on Friday I can have a look before I close it.
Yeah.
Anything is needed, I can ask.
My lord.
And Mr. Borwa, in your written note, you indicate what you want to
Yes,
do
sir.
and give a copy to the other side also. And suppose you're referring to something which is on record, just indicate the page. Then it will help me in locating those. I have already taken note of whatever you all have shown, but in addition to that, because I think the issue is whether, number one is whether the section 25 also includes
Domestic. effluent.
domestic effluent or not. That is one thing. That is one. Suppose it does, then 3,000 benchmark.
Where from?
Where from?
Why not
Now-
1,000?
now, If at all, before we part, if I can just add my argument. So it is with, Lockset has already gone for the EI notification of two
So you
thousand
give
six.
it there.
Yes.
I am not, I have only indicated
No, I-
the two
Just-
questions
Just,
so that in your written argument, you address accordingly.
just for-
Whatever you want
just
to,
for my academic.
it's all right on that.
I'm just trying to bring home the fact that when this EI notification was given, the Central Pollution Control Board has set a limit of 20,000. So from where did they get? They didn't get it very.
That is,
So-
you see,
So
Mr.
ultimately,
Borwa,
now.
Mr.
Lockset, I have
Borwa,
to complete this. May I-
20,000 and 3,000 is a huge,
Huge.
there
There lies the
has
big
to be
project and
some
small
basis
project.
for 3,000.
There
There
lies
must
the-
be some basis for 3,000
Now,
because
when,
that affairs is not discernible from your affidavit.
that is not discernible, but I will bring to home
So
the
that,
fact.
that is why I'm saying.
Because
Because
ultimately.
just because, no doubt, if you have the power, you can decide the benchmark, but it has to be some, there has to be some reasonable,
Can I-
nexus.
Can I be given just a second? Thing?
Yes,
Because ultimately, when this notification and also the schedule has been referred to, it doesn't mention 20,000 for commercial or what. They only build up area has been said. Now we have to debate upon what build up area consists of, whether it is a commercial or a residential. There my arguments rest, because it is said as regard build up area.
No, my lord, build up area will include both, including domestic. When there is no classification, it will apply both. And when the field is covered by an union law, state cannot come up with any law. That is the legal position.
I think those are the two questions
Yes,
Yes, those
that
are-
falls for determination in this writ petition.
yes, yes. When the field is covered by an union prescription, how can there be
That's your
state?
argument. I remember the arguments. The only difficulty is because the whole thing is now how, because suppose this court has to
And my lord,
read,
and the
Section
issue is so
25.
relevant in today's context.
correct. You see, that cannot be forgotten,
Yes,
right?
sir.
That cannot be forgotten.
The
Because that
purpose
is
of
the way,
enacting-
otherwise, there was no difficulty in applying the principle of issue generis and saying that it has to be understood preceding, part of the same
Tenants
thing.
is the part of this.
Correct. But while reading it repeatedly, now the object, that end, it's creating a.
Right.
Because that ultimately object is for the preservation.
And here,
That cannot be
negate.
ignored while interpreting. So now if suppose this code restrains it, then it would be a violation to the statute. The object gets frustrated. These things are all coming in my mind.
right.
Otherwise, there was no difficulty. Friday, huh? Friday as part.
Deep clear.